All right, we've got some breaking developments coming in from India's Supreme Court, which is delivering that verdict, that crucial verdict in the Babri Masjid case. As per the latest information that's coming in, the judgment is being read in that case. We also are aware that the court will be deciding whether or not the Ayodhya case will be referred to a larger bench. We are awaiting further details on the latest coming in from the court. Let's go straight across to Wion's political editor Kartikeya Sharma, who's getting us the latest. What has the court observed so far, Kartikeya?
Let me go step by step, Molly. You see, it's a very nuanced judgment which has come. Now, let me put it this way. This is a 2-by-1 judgment, which means that Chief Justice of India with the other judge, they have taken one position and other judge has taken a different position. Now, this judgment was in context of Ismail Farooqui case. Now, in the Ismail Farooqui case, it was said that mosque is not essential to the practice of Islam. Now, this was a seminal issue. A lot of people said that if you apply this to the larger case of Babri Masjid, then the case of those who are saying that there has to be a mosque here will completely get demolished. Now, the verdict as it is being read is saying that the matter will not refer to a larger bench. Because a lot of people argued, Molly, that the matter must go to a larger bench. It's a seminal question. Tomorrow people will say, well, do Hindus require temples to pray or not? Are temples essential to Hinduism or not? That's the principal question. But the judges have said that the Ismail Farooqui case was a contextual one. Ismail Farooqui judgment will not impact the other suits, which means that whatever decision has been taken in 1994 will have no bearing on Babri Masjid, one. But the matter will not be referred to a larger bench, two. So there are two things happening simultaneously. Judiciary has delinked two very important things. Now, the earlier was that when you say that the mosque is integral to Islam, was made in the context of land acquisition. So, in that context, when the judgment came in 1994, it was in context of an acquisition. So, the court here is saying that please understand that the precedent of that judgment will not be applicable to the suit 5 of Babri Masjid demolition. Which means that tomorrow you cannot say just because there is a 1994 verdict which says that, well, mosques are not essential to the practice of Islam. So, well, it resolves the issue of the temple mosque dispute of Ayodhya. No, it will not. That is not happening. But simultaneously, when the delinking is taking place, Molly, the matter is not being referred to a larger bench also. So these two simultaneous things are happening. These are the preliminary, I would say, information which we are getting from the court.
Right.
And we will have a dissent note. Obviously, there is a dissent note which will also be read out in the court. But it became important, and just for the general background of our viewers, that if the matter, Molly, would have gone to a constitution bench, then the proceedings on Ayodhya would have come to a stop till that issue would have been, or till that issue was resolved by the court. Now, the proceedings on Ayodhya will continue, but without any bearing from the 1994 case. I think it's a fantastic judgment in that way.
Right. For the viewers who might not be aware of the nitty-gritties of the 1994 judgment, Kartik, if you can elaborate for us the kind of impact that this judgment has and what that judgment earlier had said.
Oh, absolutely. See, okay, you have asked me this question in context of the older case. See, in 1994, the matter went to the Supreme Court. The Supreme Court said that the namaz could be offered anywhere and that a mosque was not necessary for this. It also ruled that the government could therefore, if needed, acquire the land that a mosque is built on. If you remember, when Narendra Modi was Chief Minister of Gujarat, when roads were being broadened there, so many temples were relocated, removed from there, dismantled, because state has that right. State has the right. So it is in this context the judgment came. Now this judgment was did not have any resonance in the Allahabad High Court, which means that Allahabad High Court, within the normal parameters, came out with its own judgment without contradicting or without going into the 1994 Supreme Court. So a lot of people said, well, that's a seminal question which remained untouched. So let us, take up this issue. So the 1994 Apex Court judgment in Ismail Farooqui, as I said, mosque is not an essential part of the practice of religion of Islam, and the namaz, which is prayer by Muslims, can be offered anywhere. Now, Muslims appellant said that the observation has affected status of mosques in Islam, and the question should be answered before the court goes into the main title dispute. Arguing for them, senior advocate Rajiv Dhawan told the court, if congregation is part of Islam is taken away, a large part of Islam goes worthless. But then if you look at the judgment, you see that's where the importance comes. So the judgment will not have a bearing, one, on the current proceedings, and plus, the court itself said, the decision was on the limited aspect of whether the law laid down by Supreme Court in 1994 judgment in Ismail Farooqui versus Union of India could be revisited by a constitution bench. So it is not going to the constitution bench. So that way, the proceedings of Babri Masjid will continue, but the 1994 the suite Ismail Farooqui will have no bearing on the Ayodhya case. It's a very important development which has taken place.
Indeed, Justice Ashok Bhushan, as per the latest information that's coming in from those court proceedings, Karthik, as you were also pointing out, saying that we have to find the exact context of the observations in the Ismail Farooqui judgment, also saying that every lawyer must acknowledge that every law is not logical. Mosque is not an essential part of Islam, has to be understood in the context of immunity from accusation. The Ismail Farooqui judgment will not impact the other suits. That is the larger message that's coming in from the court proceedings. Justice Ashok Bhushan making those categorical statements. Karthik, this of course is a judgment which will have great implications in the time to come.
Well, yes. You see what has happened. You actually you have explained it well, Molly. He has delinked it. And questioning, to our average viewer, people would be asking this question as to what happens to the main title suite. I would say that the judges, judiciary in its wisdom, have delinked it. So when you delink the matter, the presumption that since 1994 judgment has been upheld, there will be a temple there. No, you cannot say that. You cannot say that. You cannot say whether there will be a temple there or a mosque there. You cannot prejudge the future in context of 1994. But you will not have parallel sittings on this issue, which means that the time will not be delayed, which means that now judges are free to hear the Babri Masjid case, which also means that the Babri Masjid case will be continued to hear in Supreme Court despite a delay. But that delinking has taken place, which is the most important aspect, Molly.
Indeed, I want to just quote further from what Justice Ashok Bhushan has mentioned in those proceedings just a few moments ago, that the observation in the Ismail Farooqui judgment that mosques are not an essential part of the religion in the context of acquisition of mosque must be treated as observation but not as governing factor. That's one of the crucial takeaways. The present case shall be decided on its own facts. The Ismail Farooqui judgment will have no impact on it. Also saying that questionable observations in Ismail Farooqui not relevant for decision making in this suit. The Supreme Court declining reference to a larger bench is the larger takeaway coming in from the case. The Supreme Court to begin hearing on the Ayodhya matter from October 29 to decide the suit on merit is also the latest that's coming in. But very important to mention here that the court in those proceedings taking place as we get to the latest from inside the court, the Justice Ashok Bhushan saying that we have to find the exact context of the observations in the Ismail Farooqui judgment. Every lawyer must acknowledge that every law is not logical. Mosque is not an essential part of Islam, has to be understood in the context of immunity from accusation. Karthikeya, that in a way sums up what the court is trying to say.
Yes, because court is saying that the temple, mosque, churches are equally relevant. A place of particular significance of practice and religions and a different place in law. Issues in this case are entirely different. Farooqi's case doesn't decide any matter involved in the suites. You see, what has happened is very, I would say smartly, very, very intelligently, the court has delinked two things completely, Molly. What the court has done is that it is saying that the Farooqui case will not impact the title suite, and secondly, the matter is not going to go to the larger bench, so the hearing will now continue in Babri Masjid demolition. So Molly, two things happened simultaneously, because the fear raised by people were that if this argument is accepted and that judgment is upheld, then will it be like a precedence for what the judges are going to decide in context of disputed side in Ayodhya. That's where the, I would say, apprehensions were flowing. But I think those apprehensions have been put to rest. Molly.
Right, stay with me, Kartikeya. Reactions coming in. Let's take a listen in.
Otherwise were made specifically in the context of acquisition of a particular property. So fundamentally, they are saying that observations in Farooqi's case will have no bearing on the larger issues. Sir, Hindi mein
they're reacting. The present case shall be decided on its own facts. The Ismail Farooqui judgment would have no impact on it, is the latest that's coming in from the Supreme Court. Why don't we go straight across now to our correspondent Jessica Taneja, who's been tracking the very latest, was present inside the courtroom when those observations were made. Jessica, if you can elaborate for us what the court has said over the last few minutes.
Well, Molly, the court has said that it won't be revisiting the Farooqui judgment, an important judgment. Now, what the petitioners and the various parties had argued that before deciding on the 2010 Allahabad High Court verdict or the appeal against the Allahabad High Court verdict that had distributed it amongst three parties equally, the apex court said that we will not revisit it and that the matter can be heard separately as well without having any bearing on this issue. So that is what the court has come out with and made it pretty much clear that they're not moving this at least to the Constitution bench hearing.
Indeed, Jessica, another crucial takeaway that's coming in is that when Justice Ashok Bhushan says all religions and religious places need to be equally respected, Ashoka's edicts preach tolerance to faith of others. So a lot of quotable quotes yet again coming in from inside the court, if you can elaborate on those as well.
Absolutely, a lot of quotable quotes coming in from the apex court there. Rightly pointed out, Molly, he said every lawyer must acknowledge that every law is not logical. Now, the contentions which had been there for the Farooqui judgment of the 1994 was that it made there was a very contextual observation when it came to that mosques are not an essential part of Islam, wherein now that has been clarified, the observation was made in terms of the context of acquisition and not necessarily on just the mosque. It was made in context of all religions. So that demarcation was supposed to be there, but because of the observations were understood in a different manner, it led to a long hearing of sorts when it comes to this case. So that now is not being revisited. This is not going to the Constitution bench. Perhaps what remains now to be seen is that the 2010 Allahabad High Court verdict in the Ram Mandir Babri Masjid case will now, the appeal will now be heard by another three-judge bench, which of course will not comprise of the Chief Justice of India, but another bench, and that we'll have to wait for.
Jessica, my question to you is, for a larger audience, now the matter has been settled, it is delinked and it is not going to a larger bench. Does it mean that the hearing on Ayodhya case can resume?
Well, absolutely, Kartikeya, the hearing will resume, but of course that bench will have to be constituted by the new CJI, Ranjan Gogoi, in another week when he takes office. But why this judgment was being given importance of Constitution bench was the fact that the parties had said that first we need to establish and revisit the Farooqui judgment, which made these crucial observations. And now that the court has made it clear that they're not revisiting this and they're not sending it to the Constitution bench, also clarifying that this judgment has no bearing on the 2010 Allahabad High Court verdict appeal against the appeals that were filed against that verdict in Supreme Court. So that makes the path very clear for the appeals against that Allahabad High Court verdict.
Perfect. You see, a lot of people would ask, Jessica, that, does it fast-pace the Babri Masjid case? Can we say that? So I think that was a crucial question, does it fast-pace the Babri Masjid case or not? I think that's an important.
Indeed, Karthikeya, that is one of the key takeaways. The three-judge bench of the Supreme Court, led by Chief Justice of India Dipak Misra, delivering that verdict, which would impact the Ayodhya Babri Masjid demolition case in more ways than one. As we have been getting our viewers, the latest coming in from the court. One of the other observations that was made by Justice Bhushan in that proceeding, saying that all religions and religious places need to be equally respected. Ashoka's edicts preach tolerance to faith of others. Also going ahead and saying that mosque is not an essential part of Islam, has to be understood in the context of immunity from accusation. Every lawyer must acknowledge that every law is not logical. Justice Ashok Bhushan saying we have to find the exact context of the observations in the Ismail Farooqui judgment. And the 2-1 verdict that's come in from the Supreme Court this afternoon, the Ayodhya case need not be referred to a larger bench. The larger implications and ramifications, Karthikeya, will of course have to be closely monitored, as one of the crucial questions that you also raised was to what extent this will impact the case, the Ayodhya case going forward, and how soon we will expect proceedings to resume there.
I've been given to told that the 29th October is the date when the Ayodhya matter, the hearing on Ayodhya matter will be resumed. So again, that's very, very important, because this is going to happen under the new Chief Justice of India, Ranjan Gogoi. Now, Ranjan Gogoi is going to remake the bench. Now, I don't think Ranjan Gogoi will be going through all the matters of Ayodhya from beginning. I think he will be taking over the work, but once it resumes, once the matter is referred here, I think the matter on Ayodhya will be fast-paced, because there is no additional matter to be taken up. Please understand that the objection was on certain issues which they felt have to be resolved before the proceedings on Ayodhya start. What was the basic objection? Is mosque fundamental to the practice of Islam? Court says, well, that was one small verdict on the issue of acquisition. The role of the state remains supreme. They can acquire anything. Church, temple, gurdwara, mosque, but that does not have bearing on the Ayodhya case. Now, what does it happen? The matter does not go to the larger bench, but it allows the court, after reorganizing the bench, to look into the Ayodhya case. So my understanding of the preliminary facts which are available is that the matter will become routine and regular in the court. Today it is not being heard in a routine way, was not being heard in a routine way, Molly, because of certain issues like questions which were raised on this, but now the matter will be heard on a routine basis.
Indeed. Stay on with me, please, Karthikeya and Jessica. I'll just come back to you both. Also joining us on the broadcast this minute is Francois Gautier, French political writer and journalist, joining us from Puducherry. Francois, let me begin by asking you for your initial reaction to the latest that's coming in from the court, where it has decided that the Ram Mandir Babri case will not be referred to a larger bench.
Yeah, it's a relief, I think, for many people, because one has the impression that in India, the Supreme Court has started interfering and, passing judgments on all kind of, useful and, not so useful items. And this is a matter which is a religious matter, and it seems a little strange that the Supreme Court would make a judgment on it. So I think it's a relief for many people. And I have seen quite a few statements already saying that this paves the way for for an agreement between the Muslim and Hindu community. I think there are quite a few leaders, such as Sri Ravi Shankar, who are busy trying to mediate between the two communities, and one hopes that an agreement will come. I was there when the Ayodhya mosque was destroyed, and I remember that it was unused. It was a mosque which was just there as a symbol. It was unused. And in the next town, in Faizabad, there's actually a huge mosque which is totally used and where thousands of people are praying every day. So I never really understood what this dispute was about.
Right, and to those uninitiated, Francois, if you can also elaborate for them this delinking and the impact that it will really have on the Ayodhya case going forward.
Can you repeat the question, please?
The delinking, the court there saying that the Ismail Farooqui judgment will not have a bearing on the Ayodhya case. That delinking and the way it will impact the Ayodhya case is one of the other key takeaways from that judgment.
No, I do think it will have a bearing on the Ayodhya case. I mean, if the Supreme Court had passed a judgment, then the whole ball would have been in the Supreme Court's hands. And everybody, both the Muslims and the Hindus, and the government of India would have looked up to the Supreme Court for a solution. But I don't think the Supreme Court would be able to give a solution to that problem. It has to be sorted out between both the Hindu and the Muslim communities. And as I said, there are attempts at the moment to find a solution. So it is better that the Supreme Court doesn't intervene, in my opinion.
All right. Also, the court there saying that the mosque is not an essential part of Islam has to be understood in the context of immunity from accusation. Francois, you're telling us about the way this case, of course, in your own eyes has unraveled over the last few years. Your comment coming in, of the significance of these observations on the case.
No, it's a fact, that in the religion of Islam, one can pray anywhere. One doesn't need a religious building. And in my country, France, for instance, where there are not enough mosques, people pray in the street. In fact, there are traffic jams, on Friday evenings all over France because Muslims pray down in the street. So I don't think that the Ayodhya mosque is needed by the Muslim community in India. There are enough mosques all over, including in Faizabad, as I said, which is the twin city of Ayodhya. People do not know that Ayodhya is actually a Hindu city with a very ancient history, many temples, where the Faizabad is more of a Muslim city. And the mosque was situated in Ayodhya, in the heart of a Hindu shrine city. Hence, when I was there, when I saw the destruction, and before and after, when I went there again, the whole dispute doesn't make sense. It doesn't make sense to me that a mosque which is, situated on a very revered, temple, which even British archaeologists say was there, is raised, and it creates such a wave in the not only in India but in the entire Muslim world. The riots that followed in Bombay, we know that there was some link to other countries, to other Islamic countries. So it doesn't make sense. The Muslim and Hindu community should come to an agreement. I think Sri Ravi Shankar is the best placed person at the moment, who has the trust of both the communities, and there is no question of the Supreme Court intervening, in my opinion.
All right, Karthike, what do you make of those incisive remarks that are being made by Francois Gauthier?
I think he has a strong point. But before I comment on what he has said, the important thing here is, Molly, is that the doors for speedy hearing, the door for day-to-day hearing on this matter has opened up. Now, in the Ayodhya case, you will have hearings starting from 29th. What was the problem after Allahabad judgment when the matter went to the Supreme Court? First came the issue, Molly, of translation. Second came the issue of what are the issues to be taken up. Third came the issue of Ismail Farooqui, that this thing needs to be settled before the larger case has to be heard. And fourth was, which was dismissed by the court when Kapil Sibal went and said, well, Ayodhya hearing should start after 2019 Lok Sabha elections. So there were a lot of things which happened, and the hearing on the main case did not start at all. So the most important thing is that the matter has been speeded up now. The hearing on the Ayodhya case will start soon after, which is from 29th, and depending upon the position which Ranjan Gogoi takes, because he's going to take over next week, Friday, the Chief Justice of India, that's his last working day. Monday he's going to put in his papers and the new Chief Justice of India is going to take over. The transition ceremony will take place. But now this new CGI will have a complete clean slate. He can finish the matter in 60 days. He can finish the matter in 90 days. He can finish the matter in 6 months. Now there are no pending ancillary questions to the case of Ayodhya. Now what they need to do is to take a view on the judgment of the Allahabad court. So the matter has been speeded up.
Indeed, and the other takeaway, of course, being that mosque is not an essential part of Islam, has to be understood in the context of immunity from accusation. Kartikeya, that demarcation being one which has stood out in those observations.
Absolutely, Molly, because a lot of people are of the view that if in the context of the Ismail Farooqui case, the matter is being continued to hear, the title suit number 5 of the basic Ayodhya case, then it was a logical conclusion that which way the judgment or the verdict will go. Because if that becomes the premise of the case, then the case on the part of the Sunni board or the case which has been fought by All India Muslim Personal Law Board had no legal validity. That was the issue. Now the court says, well, your legal point of views are respected, they are being heard, we'll hear you out. The position by those who believe that the Ayodhya temple should be built, it's being heard. The verdict of the Allahabad court is in front of will be in front of the eminent panel, which will be reconstituted by Ranjan Gogoi, and the matter will be decided. The problem was political. The problem was the matter was not being allowed to discuss. And Ayodhya is not Ayodhya technically is a legal matter, but please understand it is also a matter of faith.
Right.
It is also a matter of politics.
Kartikeya, I'll just come back to you. Also joining us on the broadcast is Indra Jaising. Thanks very much, ma'am, for speaking with us here on Wion. Your initial reaction, ma'am, to the observations made by the court?
I would say I'm a little disappointed because the issue was deeply fundamental and is referable not just to Islam but to all religions, and the question could equally arise in relation to a temple, and so to treat it just as a pure and simple matter of eminent domain, the power to acquire property, is not what was expected from a constitutional court. I agree with the dissenting opinion that the issue has not been appropriately discussed in the Farooqui judgment and did require a full-fledged hearing. I also fail to understand what was to be lost by referring the matter to a bench of 5 judges. On the contrary, it would instill confidence in the general public in acceptability of any judgment that will have come. There is no denying that the judgment in Babri Masjid would shape the destiny of a nation. So therefore, yes, disappointed.
All right, Indra Jaising there reacting to that observation by the Supreme Court, the crucial verdict. We'll just try and reconnect that line with Indra Jaising, a bit of an audio glitch there. But the court also saying that the mosque is not an essential part of Islam, has to be understood in the context of immunity from accusation, and the Ismail Farooqui judgment will not impact the other suits. Those are the two takeaways, apart from the fact that this is a 2-1 verdict in that Ayodhya-linked case, which the Supreme Court has given out, saying that the matter will not be referred to a larger bench. But another key takeaway that's coming in just a short while back is that the Supreme Court will be beginning the hearing on the Ayodhya matter from October 29th to decide the suit on merit. That's the latest that's coming in. So the hearing will take place from October 29th in the Apex Court in the Ayodhya matter. If you were listening into what Indra Jaising was saying, Kartikeya, expressing her reaction and raising those questions as well on the case going forward.
Absolutely, because see, I'm not surprised by the point which Indra Jaising made, and just for the understanding of our viewers, you see, this case was important from 3 points of views. One was the case in itself was looking at the seminal question: is mosque integral to practice of Islam? Court says, well, that's a question in 1994 was settled in context of a acquisition case, which defined the power of the state. That is why Indra Jaising said that I am little disappointed. The reason why she says little disappointed is because a lot of people felt that it is a seminal question and required a view of the Constitution bench. But then the judiciary is saying we have delegated it. The view of that particular position will not be binding on the decision of the Ayodhya, which means that the hearing on Ayodhya starts, which means that the hearing of Ayodhya will continue from 29th, the bench will be reconstituted, and it also goes on to, we can't prejudge how Ranjan Gogoi will take over the matter, but it is a clear indication that matter will be speeded up. Till now, after Allahabad High Court, the matter was pending for translation, for people who have raised several other petitions, for people who raised seminal questions, for people who wanted the matter to be discussed after Lok Sabha election 2019. Now everything has been put to rest. Now the only question is, in context of the Allahabad verdict which was pronounced in 2010, after the arguments, what does the Supreme Court says? Will there be a temple or not? In Allahabad High Court verdict, the land was divided into 3 parts. One part went to the mosque, other went to the temple, other was earmarked for a different purpose. Supreme, and that was not agreed to by both the parties. Now the Supreme Court will have to resolve the issue, and it's an intertwined issue in India. Technically, it's a legal issue, but if you look at socially, it's both a matter of politics, it's a matter of, I would say, faith also. So it has resonance on constitutional morality also. It has a debate on majoritarianism and minoritism. It is also about how India's constitution will uphold the rights of the minorities. And it is also an issue about what do you do for reconciliation. And I'll give you an example. When Nelson Mandela went on to become the president of South Africa, he did not persecute the whites, though there was a Truth and Reconciliation Commission. So today, when people say, well, there's a democracy in South Africa, and I'm giving you an analogy, the political power was transferred, economic power continued to remain with the whites. And for that reason, there was no violence. So the issue of Ayodhya is also of reconciliation. It cannot be limited to judgment. It cannot be limited to a decision. It is not limited to a title suite. It is not limited to a piece of land. It is also about reconciliation of 2 communities in a nation, which in its preamble says is democratic, socialist, secular republic.